Good morning, good morning, good morning. Can anybody hear me?
Good morning. Yes, we can.
How's everybody today?
Morning. Fine, thank you. How are you?
Estoy bien hoy. I'm fine today, thank you. Happy to be here for another Saturday. Hope you guys had a great and exciting week. Did anything exciting happen since we last met? Anyone? Trust or no trust? No, nothing? Oh, God. I guess that means we're so consumed by our work every day. Maybe, could it be that?
Yes, it was a busy week.
Yeah, going to work every day, dealing with the issues of work. Done it, the firm. All right, I know it could become consuming. And then if you're a working student, that just compounds the problem. If you're a working student and a parent, then that further compounds the problem. So whatever category you're in, I know there are a host of challenges. Okay, let's see who's here today. Elisa.
Yes, sir.
Hey, right there. Welcome aboard again.
Thank
Leah.
you. Hi, everybody.
Good morning, Leah. Eronique. Where's Eronique anyway? From Fidelis, where's your mind? Melissa. Where's your bank again? Janice.
Morning.
Good morning, Janice. I need to find out what's going on with those Scotiabankers. They're probably wrapped up in all kinds of blah, blah, blah. All right. Did anybody have an opportunity to go over the self-assessment questions for Unit 6?
Yes, I did.
Yes, I did.
Okay. Well, let's see what you came up with. Number one.
I just need 5 minutes, but you can go on. I have to run up, go upstairs and set up, but you can go on.
No problem. I was about to say we'll give the others a few more minutes anyway, so you're right on target.
Okay, all right.
We'll give the others a few more minutes to come in, and you guys who may want to do one or two other things and settle in, finish the assessment. We'll come back in about 5 minutes. That should give the others enough time if they're going to be with us. Okay, see you in a few moments. Okay, hello. Are you guys still there?
Yes, I'm still
Yes.
here.
Okay, wonderful. Let's get started then. Melissa, are you there yet? Not yet. And Ironique is not here yet. Okay, let's get started then. Question 1. Trustee has a duty not to place himself in a position where his blank and blank conflict. What do you guys come up with?
Where is
Duty and
Judy's?
personal interests.
Yeah, his duty and
Personal interests.
yeah, personal interest conflict. Okay. That is fundamental for any area that we're in, actually, not only trusteeships, but the trustee in particular has to make sure that the job he has to do does not conflict with his personal agenda. Many trustees have attempted to do that. A couple have gotten away with it. Many of them do not get away with it. They find themselves in conflict of interest situations and they lose their account with very influential trusts. Sometimes they have reputational issues because people start talking about what has happened and future business becomes jeopardized, etc. And in many cases, it ends up in court where there is a lawsuit. So this avoiding duty and personal interest issues is a very, very serious thing for a trustee and for anybody actually who has any kind of fiduciary responsibility. Okay, so those of you who are bankers, for example, you are privy to a whole lot of personal information on a whole lot of people from all levels of life, which means your fiduciary responsibility means that you are bound by confidentiality, no matter how tempted you might feel to talk about it, even to your own spouse. Truth of the matter is, you should not, because you hold that information in trust, just like a trustee. And in essence, you are trustees of that information that you become privy to. Very interesting thing. All right, number 2. What are the general duties of the trustee? I think we looked at 3 of them.
Management duties, administrative duties, and duties of propriety.
Yes, absolutely. Okay. Of course, if you're still not clear on any of these as we go, just raise a question. But those are the 3 primary duties: proprietary, administrative, and management. And every day the trustee goes in. When we say the trustee, we're talking again about 2 types of trustees: professional trustees and individual trustees. Believe it or not, we have more individual trustees walking around than you are aware of. The world does not talk about them much. Okay? A lot of trustees are actually lawyers in law firms that are run by single individual attorneys or law firms that have many attorneys. Right? So they're not all professional banking trustees, the ones that we are more familiar with. Other ones are out there. Okay, what is the difference between a trust and a power? Anybody?
Is it that the trust, which is the duty, is mandatory and power is discretionary?
Okay,
Sure about that one.
yeah, that's kind of warm. That's one.
I'm
That's
not
one.
sure about that.
Okay, any alternative answers?
The trust involves the trustee holding legal title,
Yeah,
but they don't hold the equitable interest themselves. They hold it in trust for the beneficiary, who's the
right.
lawful owner.
Absolutely, absolutely. That's the first key point. In fact, that's the driving force behind the trustee. And what about the power?
They hold equitable and legal interests, which causes them to be the absolute owner.
Yeah, they have the power, the legal and equitable power to hold this stuff in trust. A lot of persons who are in civil jurisdictions, for example, like South America and Europe and Eastern countries, who do not trust the nature of the trust. And they do not trust it because they don't like to turn legal title over to someone else. That's really the bottom line, which is why it's so difficult sometimes to sell a trust to a South American, some Europeans in Eastern Europe, for example, and Eastern countries, because the thought of once they've turned their assets over to a trustee that they no longer own them drives them a little crazy. Of course, in the Western world, including Western Europe, trusts and legacies have been around a long time, and they are very, very comfortable with turning over assets to trustees for future generations. I had the opportunity to speak with one of the beneficiaries of the Bob Marley Trust that is somewhere floating around. And of course, Bob Marley's been gone a long time, but as you know, his music rages on and he has a legacy of his own. And so all the persons who are his beneficiaries continue to benefit from that legacy. And obviously, that trust is being administered by a professional trustee, like all the other trusts that exist around the world. And so, yeah, it's an interesting concept that the settlor has to turn everything over to a trustee who has legal title but no interest. The trustee cannot do anything with those assets except deal with them in the best interest of the beneficiaries. Very unique concept. All right. Number 4, what are considered profits for a trustee acting in the administration of a trust? What kinds of things?
Director fees,
Yep, director fees.
um, profits made when the trustee goes into competition with a business that belongs
Yep,
to the trust.
yep, absolutely. Anything else?
Profits from the misuse of opportunities and information.
Indeed, indeed, indeed. Those are the 3 key ones, but there are others. Anybody found anything else? Uh, if you do, they probably fall into one of these 3 categories. Okay. Uh, why do you think director fees are considered profits for the trustee? That's an interesting concept. Have you guys had any discussions in previous classes so far about underlying companies of a trust?
Not directly, but I guess in my experience, as probably as a professional, as a corporate trustee, someone who is either in the same company or the same company could be a director. And because they have authority over the trust, they could actually, or the underlying companies in the trust, they could actually make things go a particular way for the benefit
Indeed,
or not benefit of the trust.
indeed, indeed. In fact, that's 2 issues in one with regards to the responsibilities that trustees have as well. Because in many trust relationships, a lot of trustees or legacies have what we call underlying companies or company that is buying and selling, trading in whatever goods and services as any other company. And those profits from the company go into, then channeled into the trust fund in order to keep the trust fund liquid for the benefit of beneficiaries. And for as long as these companies are in business, those profits going to the trust fund at the end of each year. Of course, sometimes the trustee might sit on the board of that company because, like any other company, it has an independent board, and the company is supposed to be operating independently from the trust. Supposed to be. But sometimes a trustee might sit on that board so that they can make sure that the other board members in that company are making decisions that are in the best interest of that company, which will ultimately be in the best interest of the trust itself, since the company exists solely for the purpose of generating profits indefinitely for the trust. So when that trustee sits on the board, if he decides he's going to get a big fat director's fee as well, that might can be considered a profit for the trust because they're already getting their what? Trustee fees as a trustee. And if a beneficiary finds out that the trustee who's sitting on the board to watch the other board members are actually getting paid to do it, that may not go down very well with them. Okay? And somebody will eventually make a fuss about it. All right, so that's why director's fees are included there along with the others. Certainly, trustees should not be competing with the trust's business. For example, if the trustee has an underlying company that's selling a line of clothing, and because the trustee now has information on how this company works because it sits on the board, it goes out and starts its own line of clothing in competition with the underlying company, that's a problem. Sooner or later, that's a conflict of interest. Sooner or later, somebody call a beneficiary or a protector or someone will get wind of that. And that will not go down very well. Not to mention using information, proprietary information that you get by being a part of something for your own self-gain, or even worse still, to the detriment of the trust itself, and by extension, its underlying company. So there are a lot of things going on in a trusteeship other than just distributing funds every year to the beneficiaries. And a lot of trustees find themselves in trouble because they get into the routine about distributions and forget they have other responsibilities that need to be given equal attention. All right, great stuff. Number 5, the Trustee Act 1998 gives the trustee power to insure himself against, except for breach of trust in the administration of trusts. Anyone? Insure himself against?
Personal liability.
Yeah, personal liabilities. All right, and the trust will pay for that insurance coverage to protect the trustee as long as the trustee is not found to be in breach of trust. If the trustee is found to be in breach of trust and tries to use that personal liability insurance to cover his costs, it will generally not be allowed by the courts ultimately, because chances are that's where it will end up. Okay. Number 6, a trustee is required to exercise his discretion honestly, fairly, and in
Good faith.
good faith. Yeah. Now, some of these little simple words like good faith seem so simple. Like, doesn't any fool know it? Not necessarily. And oftentimes, most people know it. Knowing it is not the problem. What's the problem, anyone? Knowing it is not the problem.
Enforcing
What's
it
the real
too.
problem? Say it again.
Not doing it.
Absolutely. Sorry. Not doing it is the problem. Most of us know the hell about everything. Not everything, you know what I mean? Stuff. That's not our big problem. The biggest problem we have is, are we doing it or not? My. And trustees, like everybody else in the world, with fiduciary and moral and other ethical and governance responsibilities, we all know what we ought to be doing, generally speaking. Most of us are not ignorant about it. We just don't do it. It's like many of the major banks like Credit Suisse and the other bank in HSBC and the other one, and the other one, NatWest and the other one. They keep getting fined gazillions of dollars every year for stuff. Yet, what do they do still? Anyone? Like money laundering and fraud and anti-regulatory behavior, and but what do they still do every year still? Anyone?
Not fix it.
No. So that means they know it, correct? But they keep not doing it. How come? The question that you youngsters have to answer as young professionals going forward. How come? My. It's a big challenge. All right. Number 7. What are used to document a trustee's deliberations regarding his decision to distribute the beneficiary to a beneficiary? Anyone? 2 words.
Trustee minutes.
Trustee minutes. Is the beneficiary entitled to these minutes normally from our discussion?
No, they're not.
No, they're not. But sometimes they try to get access because they try to bribe the trustee, persuade the trustee, coerce the trustee, invite the trustee out to dinner, invite the trustee out to the Bahamas on a free weekend to relax and enjoy him or herself, whatever it takes in order to get access to the trustee minutes, just like in the Bond movies. Did you know that? Don't presume these things are not real. They are. It's just that many of us are not privy to them, but they are happening. All right, number 8. A trustee power or the discretion must be blank and no, it should be not an omission on the part of the trustee. Anyone? Or blank?
Positive mental act.
Yeah, positive mental act. Okay. In other words, an omission will not be accepted. You have to be tuned in, especially when you're dealing with discretionary trusts. I think we talked about that the last time. A non-discretionary trust poses very little challenge for the trustee because the details are spelled out and all the trustee has to do is follow it, period. That doesn't matter what he or she thinks. It's that discretionary trust that becomes the problem. How do we exercise our discretion prudently? See that word again? Prudently. It must therefore be a positive mental act. We don't just jump up and act according to how we feel or who we like or who we hate. It has to be very constructive in exercising discretion. All right, and then number 9, a trustee act fairly and independently must not be seen as a blank or blank for a set law.
As a puppet on a string or a nominee.
Yeah, as a puppet, I like that. So as a puppet on a string, okay, or a nominee. The trustee must be independent in his actions. And of course, remember when I say the trustee in his actions, I mean professional or individual. And I also mean his means her. Okay, does his mean her anymore? Or is that no longer the anyone? Does his mean her anymore in the 21st century?
It means all kind of things, no?
Yeah, suddenly it means all kinds of things. For 5,000 years, it meant both men and women. Now it means all kinds of things. Isn't that amazing? In a couple of years, it's turned into all kinds of things. Okay. That's interesting. The reason why I raised that, because you might say, well, what does that have to do with trusteeship? Well, everything we do has to do with who we think we are, including trusteeships. And believe it or not, whether you think so or not, you will administer a trust if you're a trustee, oftentimes based on who you think you are and what your agenda is personally, even though you have guidelines. Hmm, that's interesting. Okay. Any more questions about Unit 6? Anything that's still pressing, or you're pretty comfortable with that so far? All right, fantastic, because those trustee powers and duties are absolutely critical in properly administering a trust. It's just like powers and duties in any other capacity, powers and duties that you may have at your own job from day to day. There are things you can do, cannot do, expected to do, expected not to do. Similar, same kind of thing. In some ways, you guys are constructive trustees on your jobs, in your church, or wherever you are, whether you're aware of it or not. Because once you take possession of confidential information and people's information and that kind of stuff, or somebody leaves something with you or tell you something in trust, whether you know it or not, you become a constructive trustee and you have some of these same duties and responsibilities that we're talking about, whether you realize it or not. Okay? All right, just thought I'd make a real life correlation there, just in case you run into these things for real. And I'm sure you have in one form or another, and you will see it many, many more times. All right. So Unit 7 then talks about trustee remuneration. That word. Anybody knows what it means? Remuneration. Ever heard that word before?
Yeah, you get paid
Yeah,
for doing something.
paid.
Yeah, remuneration is when you get paid. So every time you guys get a paycheck at work, you are being remunerated for your services. And so trustees have the same expectation, except for the trustee, remuneration is a very interesting exercise. For those of you who have read Unit 7 already, you probably would have seen some of that. Okay. And what makes it interesting for the trustee? Well, first of all, there are laws relating to trustee remuneration. By the way, speaking about remuneration, have you guys heard that the minimum wage floor is going to be increased from $210 a week? Yes, no?
You said the $210 a week?
The floor is now $210. It's going to be increased.
Oh, okay.
Yeah,
No, I didn't hear it.
yeah. Well, it is going to be. Is that good or bad?
I guess it has its pros and its cons.
Of course. What do you think is one good thing about it?
We could all use some more money.
We can all use more money. Absolutely. Okay, we can all use more money. No doubt about that. No doubt. It will make more money.
And that's based
available.
on the cost of living as well. You need more money.
Plus, you need more money because the cost of living is going up, has gone up, somewhere in there. So those are two driving forces for needing more money, for sure. Those are a couple of good benefits. What would be one disadvantage of increasing the minimum wage? If there is a disadvantage at all, anyway.
In the instance of businesses that are probably operating on a minimum wage basis, they may end up losing staff because their model can't afford to maintain them.
As crazy as that sounds, economically speaking, that is an unfortunate truth. The extent to which because remember, the reason why I asked, because is the Bahamas government trustee for the country?
Yes.
Absolutely. I'm just trying to show you that this stuff doesn't only apply to a firm or an individual on a financial trustee basis. Governments are trustees for their countries. They have a fiduciary responsibility. Who are the beneficiaries?
The citizens?
Of course. Who are the protectors? The courts. See how that works? Because remember, I don't know if you had any discussion about protectors yet. Have you?
I don't think so.
I don't think so. I don't recall.
My. So you guys are well on your journey then. You have a whole lot more interesting things to go. So I'm throwing out some stuff that you'll hear some more things about when you move on to the next levels and the next stage. There's a second stage to trustee stage 1, and it's called trustee stage 2, which you have to do. There's all kinds of crazy and interesting stuff in there that you need to know. This particular stage 1 is just to get your feet wet, warm you up, introduce you to the fundamentals, so that when you get into deep waters, instead of drowning, you just float, swim, and have a ball learning new stuff. That's the whole idea. So who's the protector in the trust? The protector in the trust is selected by the settlor once he has settled his trust with the trustee. And the job of the protector is to watch the trustee. How about that? To make sure that the trustee is doing what, you think, anyone? What do you think the trustee is watching for?
All of the trust duties based on the trust instrument and the law.
Yeah, make sure that the trustee is basically carrying out his duty as trustee, which is for the benefit of beneficiaries. And if the protector says that something is happening to the contrary, the protector has a duty to confront the trustee and tell him to fix it. And in some instances, report to the beneficiaries, if necessary, in order to get the trustee to fix it. And in some instances, recommend that maybe legal action is required because the trustee will not fix it. It's like everything else, when we become powerful enough, we start thinking that we're not accountable to anybody, even unto God. How about that? The God who's God doesn't exist anymore. I'm God. And sometimes trustees and other persons in power get that way. They forget that they are still accountable to someone, something, some group. All right. So there's a law
So
regarding
the protector is there to kind of keep the trustee in line then?
absolutely. All right. Now, keeping him in line doesn't mean he walks around him every day with a big stick and say, "I'll hit you in your head if you." Not that kind of line, but the line that you mean and you're correct is that they're there watching. Yeah, just to make sure that the trustee is not doing anything contrary to his responsibility as trustee. So he's watching.
Following what's in the document.
Absolutely. All of that would be outlined in the trust instrument. Okay, for sure. And if you see a trust instrument where there's no protector, now that you have a little information already, you should wonder, like, where's the information on the protector? And then you may want to find out, like, why isn't any protector in this trust? What could possibly be the reason? And so on. Okay. So yes, all of that would be outlined in the trust document. Anybody knows another name for trust document? Instrument? It's another name for trust instrument.
Trustee.
Trust deed, yes. They are interchangeable expressions, so one means the same as the other. In case you see one or the other. All right, so there are laws relating to trust remuneration. There are circumstances when a trustee may be paid or not paid. How about that? And then, of course, there's the discussion of fairness in trustee remuneration. What is a fair pay for the trustee? Should they be paid that? If they're being paid more than they should be, what do you do about it? Because some trustees do the same as other people, they overcharge. You guys know anybody who overcharge for services? Like they charge more than they should, in your opinion? No, you don't know anybody or company like that? Okay. Any lawyers in the room? No? Do lawyers tend to overcharge sometimes? Is that a yes or a no?
I'm having a hard time agreeing and disagreeing. Just because I know that sometimes we think people are overcharging, but in reality, what's happening in the background could really be justified.
Indeed. So basically, we can justify overcharge what we think is overcharging sometimes, and then is there really ever any overcharging going on, or everybody's fair? Is everybody
I'm
fair?
sure people are not always fair.
Welcome to the real world. Both of you are correct. All right. Good luck, you, the youngsters of the future, and just being the devil's advocate, throwing some things out there for you to consider as you go forward. Okay? As trustee or not. Because remember, for some reason, we always seem to be trustee for something anyway. Are parents trustees for their children while they're underage?
Yes.
Absolutely. See that? This is not just about some professional trustee somewhere. We're all constructed trustees somewhere, informally. And so if parents are trustees, who are the beneficiaries of that trust?
The
Children. Yeah,
children.
children. Absolutely. Absolutely. And so, like any other good trustee, parents have a responsibility to do everything in the best interest of the children and do nothing to harm them. How about that? Hmm. So, when a father is having an incestual relationship with his daughter, is that good trusteeship?
No.
No. It's amazing how these things are connected once you connect them, and they're all quite relevant. I know I took you out of the text for a moment, but that's okay. Let's go. So, what is it about trustee remuneration that is of importance to you as students and to trustees in the real world? All right, I think I've yapped enough. Let me see if I can get somebody to help me talk this morning. Elisa, are you still there?
Yes, I'm here.
Okay. The reason why I called you is because your name is at the top of the list they gave me. So I didn't pick on you. I'm just doing it randomly, if I could be considered random. All right. Why don't you pick up the opening salvo? A trustee may charge. See, a trustee may.
Okay. A trustee may charge for his services to the trust without being in breach of his fiduciary duty, if the trust instrument expressly permits him to do so. The charging clauses in trust instruments are strictly construed by the courts. Read Chapel 1884, rewrite 1898. A trustee must ensure that the trust instrument allows for remuneration before acting as trustee, so that his services are adequately considered and duly compensated. The express statement of remuneration in the trust instrument is the most optimal way in which the trustee can be assured that his remuneration is authorized. It is even argued that express charging clause in the trust instrument will be allowed even though it may enable a trustee to gain from a fiduciary position, and even though it may produce a conflict of duty and interest. Space Investments Limited versus Canadian Imperial Bank of Commerce Trust Company, Bahamas Limited, 1986, and Sargent versus National Westminster Bank, PLC, 1990. Even though there is a charging clause in the trust instrument of the trustee, even though there's a charging clause in the trust instrument, the trustee may only charge what is reasonable. A trustee is entitled to recover out-of-pocket expenses from the trust estate if they are legitimate. Such expenses include litigation costs or paying fees to agents. Spite versus Gunn. If a trustee takes funds from the trust in excess of what is reasonable, he may be sued by the beneficiary for breach of trust. The
Okay.
court also has.
Let's take a pin for a second.
Yeah.
So you can see right away, some in those 3 paragraphs alone, we come out firing about trustee remuneration. First of all, she says there's no breach if it's included in the trust instrument. That's the first thing, which means that whatever remuneration that the trustee hopes to get and seeks to get, he must make sure that is outlined in the trust instrument. If it's not, and he seeks to charge, he could be sued and lose. Okay?
I have a
That's-
question about that, please.
I was hoping, yes, let it rip.
What if the trust instrument doesn't specifically say what the figures are, but says something like figures that are agreed on from time to time between the trustee and whoever?
That's a good point. If it doesn't specify an amount and it just says as agreed, then if any discrepancy shows up later on, then there should be subsequent documentation to support the as agreed clause. See my point? There must be a document that
Yeah.
says we agreed to this amount for 3 years or that amount for 5 years. And so if the subsequent documents are there in support of such a clause, such a vague clause, then the courts would more than likely uphold it. However, if you have a vague clause such as that and no subsequent documents confirming the amount, then the matter will be brought into question and the courts may rule against the trustee. Of course, the courts may also look at the trustee's position, the size of the trust, the amount of the legacy, and say, wait a minute, this clause is vague, but we should still consider a fair compensation, even though it is not clearly outlined, and even though there are no subsequent documents. Therefore, it is in the court's judgment and fair ruling that based on what is a reasonable cost, which is my next point, the trustee should still be remunerated, or whatever they took already is reasonable, or what they've taken already despite this vague clause is not reasonable, therefore return the amount that's not reasonable. How about that? Point I'm making is to answer your question, yes, you can have a vague clause as long as there's subsequent documents to support it. If you don't have those things, it ends up in court as usual with any other legal matter. Matter of fact, I'm teaching a course in law as we speak, criminal business and civil law, where it's always a good idea to try and avoid going to court, because once a matter gets to court, it is final. There's no more room for blah, blah, blah. Right? But to answer your question, yes, that's possible. It's always better though if it's clear, for sure.
I have a
Noted.
question.
Yes.
When you say as agreed, this
Yeah.
is agreed by the trustee and whom else?
The beneficiaries typically. Because
Okay,
in a trustee, your biggest problem potentially will be the beneficiaries. Because remember, you only exist for their pleasure, correct? Correct? So to speak, to do what is in their best interest. So when it comes to remuneration, whatever agreements that are made. Now, if the initial trust instrument is set up with the set law and they agree on the amount with the set law during the initial settlement, then it's with the set law. But if after, let's say there's a open clause with no stated amount, and after 5 or 7 years, the trustee decides, you know what? This amount that was originally agreed is not enough for the work I'm doing. Then they will have to approach first and foremost the beneficiaries and say, guys, this is not enough. This 3 million a year is not cutting it. We need 5 million a year now. And see if they can get the beneficiaries to agree. If the beneficiaries all agree unanimously, then it'll be done. If one beneficiary disagrees, it generally cannot be done. If one beneficiary disagrees and the others say, well, the rest of us agree, and the trustee goes ahead, that one beneficiary can then bring a claim against the trustee in court, which the trustee could potentially lose because one beneficiary did not agree. Usually, we want all the beneficiaries to agree to whatever matters arise, whenever possible. And if a trustee cannot get all the beneficiaries to agree, typically, then the trustee, if it's important enough to the trustee, will then go to the courts themselves to seek redress against the disagreement of the beneficiaries.
So just to add to that, I think you answered my question, but just in case, if it's an instance where all of the beneficiaries are minors and the trust has a protector, would it then be the protector who would have to make that agreement?
Unfortunately, the protector usually doesn't have that kind of power unless the trust instrument gives the protector that power. You follow? Typically, the
Yes.
protector's job is just to oversee and raise any questions about any issues that may not be consistent with the activity of the trust. As far as that aspect of things are concerned, if they are minor beneficiaries, for example, the trustee is especially responsible for minor beneficiaries more so than those who are not. And the fiduciary responsibility is significantly greater for minors and handicapped beneficiaries. Okay, the trustee can step in and say, "Wait a minute, whatever the hell is going on, this is not in the best interest of the minors or the handicapped beneficiaries," and make a big stink about it. But depending on what the functions of the protector are in the trust instrument, the trustee may or may not be limited, and as far as they can go. Okay, for sure. Again, if all the beneficiaries, for example, are minors or handicapped and there are no responsible beneficiaries over the age of 18 or who are not handicapped, then it presents an unusual but unique situation. The protector might then decide, we don't have any beneficiaries that are over age to present this matter. Maybe my position as protector, even though it may not even be in the instrument, I'm taking the matter to court, see if I can get something going on in the interest of the underage or handicapped beneficiaries. And again, this would have to be in a case where trustees are acting way ultra vires his responsibility as a trustee. And that's not an impossibility. People do all kinds of interesting things. Generally, though, we don't see that too often, but it can happen. Okay? All right. I told you it's a very interesting area to be. And you've only just begun. Imagine the exciting things you're going to see over the next 5 to 10 years and when you actually get into this crazy stuff. All right, notice in the first paragraph again, she said the charging clause in trust instruments are strictly construed. That means the courts tend not to deviate until you can give them a good reason. If there's no room for remuneration in the trust agreement and the trustee makes a case for payment, they have to make a strong case to the courts because the court is going to first look at the instrument and say there's no arrangement here. And the trustee's going to have to get a QC or some good lawyer of its own and say, hey, maybe not, but here's why we think saying that we should be remunerated and why the amount should be this. And if they can make a strong enough case to the courts, get the courts to agree, then fine. But generally speaking, the courts are going to follow the instrument first. Often they change their mind depending on the circumstances, but instrument first. Let's not forget, she said something about fees must be reasonable. I guess that goes to the original question said earlier, do people overcharge? Some people say yes, some people say not really. It only looks like an overcharge when I consider my time and my skills. I don't think it's an overcharge at all. Okay. It's like when you go into the doctor's office for a thing, they put the thing on your chest and they listen to your heartbeat. Okay, it sounds good. And then they put something in your ear. And because they have the skills and so on to identify certain things which we don't, besides we can't look in our own ear anyway. Like, okay, that's good. And they look in our eyes, oh, you're not completely blind yet. Great, knock your knee. It moves. It's okay, you have mobility. All right, thank you very much, Mr. Jones. I'll see you next time. You can pay on your way out. And then they said, how much is that? Is it $375? I said, oh my God, I was only in there for 10 minutes. $375 for 10 minutes? And so sometimes we want to sue, but like somebody said, we're not perhaps in that instance paying for the 10 minutes, we're probably paying for the skill and the ability to diagnose and so on. So it's all relative, interesting stuff. But for the trustee, doesn't matter what we think. It has to be considered a reasonable fee. Otherwise, beneficiaries can sue. And many of them do every day. And they're suing more and more now because beneficiaries back in the day from the 20th century back, they just kind of go ahead and trust the trustee. whatever the trustee says was gospel. Now the 21st century beneficiaries, the new yuppies, Z generation, they're I'm not trusting any freaking trustee. I want to see, I want to know, I want to hear, and if I don't like it, I'll sue you. And don't get me mad, I'll get together the other trustees and change you to another trustee. Don't get me mad or something. And these are things that are not in the textbook, but they are the things that exist in reality. Okay? So the charge must be reasonable. The trustee cannot charge anything he feels like. Any out-of-pocket expenses is allowed. The trustee can collect on those if they're legitimate, because sometimes people put out-of-pocket expenses that are not legitimate. You know, like a dinner party with the Shah of Iran who's dead or something. That's not legitimate. But sometimes people still try to collect on it for one reason or another. All right. Have you guys had a chance to look at any aspect of the cases so far? Like let me have a look, see what that case is saying, if it really means that. Anybody? Or when you open the case, you're like, man, I have too much time. I have too many things to do.
I haven't studied any cases in these sections.
You know what? What I do admire is the fact that you confirm that, hey, I haven't gotten that bloody thing yet. I get it. All right. When I was doing this stuff a million years ago, I'm like, man, I'm too busy. Cases. I have problems of work trying to keep a job, fighting with this bloody, this thing, that thing, the other thing. So absolutely, I get it. When you do get around to looking at cases, those of you who have time in one form or another, you can read through it if you really, feel excited about it. Those of you who are time constrained, just look at again, the core, the opening, what is the case? What is the claim? What was the decision by the court? And see if it's consistent with the information that you're actually reviewing and studying. Okay? Just for the record. Again, you don't have to remember all the cases in detail. That would be madness. You're not here to be lawyers and to understand and remember all the facets of a whole host of cases. But if you do have a moment to read through the core, like I said, the beginning and the end, to say, okay, what was the problem? What was the decision? That would be perhaps a good start for you guys, okay, at this stage of the game. All right. If the trustee charges an amount in excess of what is deemed to be reasonable, he may be sued. By whom?
Beneficiary.
For what?
Breach of trust.
Yeah, that would be the claim for breach of trust. Many beneficiaries have sued and many have won. Many have sued and many have lost. The point is, if you're a trustee, just know that it could happen. And just like many other organizations, for example, if somebody defrauds an organization, steals money or whatever, a lot of times organizations do not prosecute them in court because court is public. And organizations don't want the public to know that they have been defrauded by their staff. So what do? They just ask them to resign. They do not bring them before the courts, prosecute them, and jail them. Too much publicity. Trustees are like that too, sometimes. They try to avoid legal action brought against them by beneficiaries and try to settle out of court if possible. Sometimes it's not possible for one reason or another. All right. Keep going, Alicia.
The court also has jurisdiction to authorize the payment of remuneration to trustee for past and future services to the trust, notwithstanding the fact that the trustee may have accepted the unpaid office prior to rendering his services. Case Bainbridge versus Blair, 1845. In exercising its jurisdiction, the court will consider the following information, as in the case of Reed Duke of Norfolk Settlement Trust. The protection against claims of the trustees, particularly in light of the gratuitous nature of the office. The trust should be well administered and regard should be paid to the nature of the trust, the experience and skill of the particular trustee, the amounts which he seeks to charge compared to to what other trustees might require to be paid for their services. Any other circumstances which may be relevant?
Thank you, Alicia, for that. So before we go any further, it is important to note that what the court will consider, see? Remember we said, when all else fail, we go to court. Theoretically, we should all try to avoid court. Okay? I was just having a discussion with students on mediation and negotiation and all that stuff, trying to take steps to avoid going to court. And it's amazing how many people, first of all, bypass all those options out of court, including an outright settlement, because they are determined they want to go to court. Nothing's wrong with that. And depending on who you're dealing with, mediation, negotiation, and all that stuff, arbitration may not be the answer anyway. Depending on the situation, you may want to take your chances with the court. But in any event, we have all those things available to us to keep us out of the courts, because once it gets to the court, it is all final. Okay? So even though we are told that the trust instrument is going to be construed by the courts in its pure context, sometimes the court will still make provisions for the trustee. Okay? The court knows that the work of the trustee is gratuitous, meaning generally, oftentimes free of charge. There are many trustees, especially individual trustees. Professional trustees tend not to do free work. Let me just put that on record. Professional trustees do not do free work, gratuitous work. Could there be one or two out there that are professional trustees that are doing it? Of course. Could be for whatever, some other reason. But typically, a professional trustee will not do gratuitous or free work. Individual trustees, though, oftentimes do gratuitous or free work because they have been asked to be a trustee by a family member to hold a life insurance or property or other assets in trust in the event of their premature death, that they will look after those assets on behalf of their children, especially if their children are minors, until they become responsible, and then they will turn over the assets to their children. Those kinds of trustees typically don't get a fee. They just say, you're my sister, we grew up in the same bunk bed or whatever. How can I charge you for this service? It is my pleasure, sister, or whatever the relationship might be. And so oftentimes individual trustees are free. Okay. However, sometimes there might be an individual trustee who may not be a relative of the person, and they might say, I'll act as trustee, but this trusteeship involves driving up and down, gas money, a certain amount of professional information. I'm a trustee, diploma student from STEP. I'm a STEP certified, blah, blah, blah. I need some compensation for my services. And so even though I'm an individual trustee, I can't do it completely free. I can do it at a reduced price for you, but not completely free. So these are all trust remuneration issues. Okay. But again, if, for example, a trustee was doing a trust gratuitously and they decide, you know what, we need to be paid for this, they will take it to court. And the court will oftentimes consider it in the context of the case that is presented to them on a case-by-case basis. And what does the court consider? One, is this trust well administered? And should the trustee be paid based on the way that they are managing this trust, their experience and skill with this particular trust, and so on? And so the courts will consider all the variables, quote unquote, before they take a decision to make the decision that a trustee should be paid for their services as opposed to providing it on a continuously gratuitous basis. And of course, the last point she made was any other circumstances which may be relevant. And of course, that is very much a context of a court situation. because a lot of times things get to court that are not based on contract directly anymore, or is ultra virus to any contractual arrangements, and in this case, any trust deed. And so the claimant may be making some stuff that are outside of the deed, outside of the norm, to the courts that may be unusual, and they would be considered to be other relevant circumstances that the court would be asked to consider. And oftentimes they do. Sometimes the claimant benefits, sometimes they don't. Welcome to the courts. Okay. All right. Okay, Leah, you next on my hit list. Are you there?
Yes, I am.
Okay, Leah, can you pick it up, the jurisdiction of the court?
Sure. The jurisdiction of the court may be exercised to give a trustee remuneration either for past or future services, or to increase the remuneration of a trustee where the level is unacceptably low. Additionally, as in the case of Re Keeler Settlement Trust 1981, the court also has inherent jurisdiction to permit trustees to keep remuneration they had taken in breach of their fiduciary duty, and ordered an inquiry as to future remuneration for some of its trustees. Notwithstanding the fact that such agreements are rare due to allegations of undue influence which may be made against them, trustees may contract with beneficiaries who are sui juris and absolutely entitled for remuneration. Such beneficiaries will be bound by these agreements. See I. Leaf versus Murray 1740. Where trust assets are situated abroad and the law of the country where the property is situate allows trustees to receive remuneration, and trustees under a Bahamian or UK trust receive such remuneration, they will not be bound to account for it unless they went out of their way to obtain it. North Cokesville Trust 1949. As a corollary to the remuneration of trustees in the rule in Keach versus Sanford, which states that a trustee must not allow his interests and duties to conflict. Additionally, a trustee is not allowed to take any profits from his position as trustee unless these profits have been authorized by the trust instrument, the beneficiaries who are sui juris, or the court. Boardman Phipps 1967. Similarly, a trustee cannot purchase trust property for himself. Tito Waddle 1977. This is not a duty imposed on trustees, but a disability. Any purchase of trust property by a trustee at the instance of a beneficiary will be voidable no matter how fair, open, or honest the transaction may have been.
Wow. Okay. A full page of power-packed trustee stuff that trustees and all related to a trust would do well to keep in mind. Remember, whatever organization you work in, if it's, let's say, the trust environment, everything always seems fine until something blows the lid. And then all of a sudden, this stuff that you studied years before, like, wait a minute, didn't we discuss that before back then? So this thing is real. And the answer is, it is real. A lot of it goes on every day. You just don't hear anything about it in your own world. A lot of these things, if you work for a trust company going on in your company, it just doesn't get down to where you are processing transactions on a day-to-day basis. It's up the ladder in some smoky room somewhere where folks are discussing how to deal with the latest lawsuit with their attorneys that came from beneficiary number 7 or whatever the case might be. Notice sometimes the court will go back and agree to remuneration from past or future, even though it's not in the deed. Or if it's considered to be unacceptably low, the cost for, you know what, that's really $1,000 a year. No way. They can't even pay BEC bill for this company. Not only is that unacceptably low and we approve everything they took without stressing them, but we are also going to consider increasing that to a reasonable amount so that this trusteeship can function and pay its bills, whatever they might be. Okay? So you see the courts are very much involved in these kinds of matters. Okay? And so much so that in Keeler's Settlement Trust 1981, we were told that courts will even allow trustees to keep remuneration in breach of their fiduciary responsibility, meaning that the instrument didn't allow them to get remuneration, but they took it anyway, and then somebody sued, and the court said, you know what? we'll allow you to keep it because the circumstances render it's reasonable. Okay. And then they'll look on and see if there's anything else that they can do with regards to future remuneration. Should it be the same? Should it be more? And so on. But the courts are very much involved in these issues. Okay.
I have a question. I just want to make sure that I'm understanding. A case like that could be an example, I guess. Would it be where the assets of the trust have grown so much from what they were in the beginning that it requires so much more work that there now needs to be actually some remuneration that maybe never existed, or the increase to kind of match what work is being done to manage and administer?
Without a doubt, that is one of the key reasons for those kinds of situations. Yes, the trust has grown, and therefore what used to be sufficient is no longer sufficient. The responsibilities and the risk and the potential liability of administering this grown-up trust, see, have changed since 1977 or 55 or whatever the period might be. And therefore, yes, there's justification. Okay? Excellent point. And that's one of the key reasons why petitions are made to the courts by trustees. Because some of them picked up a legacy trust way back when. They're so happy to get the business, they don't even think about the fact that the money is no longer enough sometimes for that particular trust. And therefore, when they catch themselves, like, wait, one cotton picking minute, this is definitely not enough for the administration of this trust. We have 2 lawyers working on this now, 3 accountants, and 5 trust officers. No, 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 no. And we have to pay them all this money per year with benefits on this bloody job. There's no way that this old fee that we collected right after they shot Lincoln is going to be sufficient. Okay, so yes, that is a good point. Okay. Notice also, Leah said the trustees make contracts, with beneficiaries who are sui juris. What does that mean? Sui juris. Anybody said what that meant before?
Requisite age and mental capacity.
Yes, requisite age and mental capacity. So you have to be 18 or older, depending on what country, state you're in, or 21 or older, depending on what country you're in. Back in the day, 21 used to be the legal age, in case you guys didn't know. And I guess politicians must have changed it to 18 so they could get more votes. I don't know, just throwing that out. But the legal age for drinking, legal age for anything used to be 21 in the Western world back in the day, which is probably still a good idea, but what can I say? Kids are so excited. I'm 18 now. I can do whatever I feel like. You can't tell me what to do. Just keep looking after my well-being and let me do what I feel like doing, sort of thing. I'm 18. Okay. Let me ask you youngsters a question. Is 18 a mature age? Is it?
I don't think there's really any mature age.
That's an interesting observation. And whether you believe it or not, there is some truth to that. But in the context of what the law and society and all that stuff, I like that. Because I've seen some people over 50, they might as well be 15 for one reason or another. And so, yeah, there is some truth to that. Certainly when a child turns 18, they have maybe physical attributes that make them mature physically. But the other aspects of life are not necessarily going to kick in at 18, for sure. All right. So, she's not sure at what age. That's a good one. I like that. So trustees may contract with beneficiaries who are sui juris and absolutely entitled from remuneration. So they might say, hey, trustee gets together with all the beneficiaries, say we need an increase in salary, fees or whatever, and they may all agree. They're like, so, yeah, we feel sorry for you. You should have said it a long time ago. It's a bunch of work. That's a bunch of agreeable beneficiaries. They're not all that agreeable. Okay. But once they make that decision and all the beneficiaries agree, then they're bound by that. They can't come back later and say, well, we want to change it. Contract is a contract. And generally, if all the beneficiaries agree, the courts will uphold it for an increase in fees. If one beneficiary disagrees and the others sign a contract with the trustee, and the one who disagreed takes it to court, the contract can be voided depending on the details of the case, or not. How about that? Welcome to the court. What else did Leah say? Trust assets abroad allows trustees to receive remuneration like in the Bahamas and the UK. Okay, so yeah, we can arrange for remuneration under our trustee laws, and sometimes we don't even have to give an account for it, unless of course it can be proved that we went out of our way to seek remuneration for some reason, like maybe go to the beneficiaries and create a contract or some other such situation. But generally, in jurisdictions like the Bahamas and the UK, because our UK trustee laws are very similar to our local trustee laws are very similar in some instances to the UK laws, updated from modern trustee activity. In that case, it's a little more modern than UK law, trust law. But our original trustee act was based on the UK trustee act. And then, of course, when trust business became more competitive in the Caribbean and Western world, a lot of us had to go back and change our old UK conservative laws to more modern trustee laws that can accommodate the settlor and the beneficiaries and all these other kinds of things, which is why we end up with a whole lot of sham trusts sometimes, because sometimes our trustee laws are so quote unquote laxed that we allow the settlor to also be a beneficiary and sometimes be a protector too, which is a kind of interesting conflict of interest that nobody talks about publicly, but it could happen and has happened. And we can see the problem with that already. And oftentimes when the settlor is a beneficiary, but the settlor is allowed to exercise undue influence over investment decisions, etc. Remember we said earlier, if we find that too much of that is going on and the settlor is running the trustee, what do we call that kind of trust? Anyone remember?
A sham trust?
Yeah, sham trust, S-H-A-M. The settlor is not supposed to be running the beneficiary, period. Sorry, the trustee, period. Period. It is always a good idea if the settlor is not a beneficiary, but they could be. Because if the settlor is a beneficiary also, then the settlor is going to buy his very, in fact, man, those are my assets, even though he doesn't own them legally anymore. So that kind of settlor who's a beneficiary could be a pain in the butt for a trustee as well. Trustee tries to get an agreement with the other beneficiaries. They all agree except that one because he's the settlor or she. And she says, look, man, I'm the original settlor. And I don't like it as a beneficiary, and therefore I don't like it. I'm not signing it. Yes, it's reasonable. I'm not signing it. Why? Because I don't feel like it. I'm not in a good mood today. Call me again in 6 months. See, and so on. And so the trustee is stuck with a beneficiary that is disagreeable, especially the beneficiary is actually the settlor of the trust. So those kinds of things can create serious conflicts of interest for the trustee. So trustees have to be very careful when those kinds of things show up. What else did she say? Part of our question and answer in Unit 6. Trustee must not allow his interests and duties to conflict. We know that now. Trustee is not allowed to take any profits. We know that now. Unless, see? The subject to, unless the profits have been what? Anyone? Trustee can take profits under 1, 2, 3 conditions. What are those 3 conditions?
Authorized by the trust
Authorized.
instrument, authorized by the beneficiaries who are sui juris, or authorized by the
Absolutely. So it doesn't have to be argued anymore that the trustee cannot take profits. Sure, you can as a trustee. However, one of those 3 have to exist, or all 3 of them. But you don't need all 3. If the instrument says it, that's it. If the instrument doesn't say it, then you go to the beneficiaries, and then that's it. If the beneficiaries don't agree, then you can go to the courts, and then that's definitely it. If you don't like the court's decision, you can appeal it to a higher court, but it's still the courts. And you might win the appeal, actually. So don't be afraid to appeal. That's the other thing. But the courts are the courts. Their decisions are final. And then the final point she made was the trustee cannot purchase trust property for himself. Wow. Any purchase arrangement that the trustee makes with any beneficiary will be deemed to be void, no matter how much of a market arm's length transaction it was. Anybody have any idea why that is so, potentially? Why do you think that is so? Trustee cannot be purchasing trust property and making contracts with beneficiaries to do so. What's the problem with that? Starts with C.
Conflict?
Conflict of
Of
interest.
course, of course, of course. Trustee has too much inside information to be able to make that kind of deal. And that kind of deal can run contrary to the interests of other beneficiaries as well. The hell he can be buying a trust property that belongs to whom? All the beneficiaries, correct, everybody? So there's some problems with that right away. Should never be considered. I wouldn't say a court will never consider it, because there could be an extreme case where it's allowable. But again, that would preferably be a matter that is sanctioned by the courts and nobody else. I don't think you'll see any such sanction anywhere else. Because remember, the trustee's first duty is to protect the assets of the trust for the benefit of the beneficiaries. Everything else comes after that, including even the trustee's remuneration. How about that? So it does beg the question of the huge responsibility of a trustee, especially a professional trustee, and certainly any trustee in any capacity that has a fiduciary responsibility and a duty of confidentiality. My. Okay. Some great questions so far. I love it. That means you guys are thinking about this stuff, and that's good, because when you get into your professions deeper and deeper, you will find that you will want to be thinking about these. You'll be asking questions about these. Depending on where you are in the organization, you will get straight answers, and other places you will get crooked answers, and other places you will get no answers, and you still have to decide what you're going to do about it. All right? Okay. Did anybody attempt the self-assessment in Unit 7 in anticipation of today's class? No?
I did.
You did. Okay. Now, that's what I'm talking about. All right, well, let's give it a shot. Let's give it a shot. Number one, a trustee is allowed to be remunerated, that should be remunerated for his services if the blank expressly allows it.
The
blank?
trust instrument.
Yeah, the trust instrument, yes, yes. Number two, in exercising its jurisdiction, what information will a court consider? What information will a court consider generally in exercising its jurisdiction?
If the trust is administered well, the skill of the trustees, how much they're asking for.
Okay, yeah, anything else? Any protection of against any claims? That's one of the other ones. Protection against any claims that the trustee might make. And what about that third one that we said? If nothing falls in anywhere else, what do we call that third category? Other relevant situations, whatever they might be. Remember, once a matter gets to court, the court will hear anything that makes sense in your opinion. And they'll decide if it makes sense in their opinion. And then a ruling will be made. Okay? Let's not forget also that one of the things that the courts will consider is whether the trust is administered well or not. If a trustee comes for remuneration or an increase, and the courts decide that the trust is not being administered properly based on the facts, they will not consider the increase. In fact, they might say you should need to get a decrease because you're not administering this trust properly anyway. Mr. Trustee, you're coming for more money? You haven't earned the money you're making now. And that's one of the risks that trustee takes when you're looking to the courts for more money. You better be satisfied that you're running a trusteeship properly. Because if the beneficiary or whomever is making the case, or the courts even, says, okay, fine, you're here for more money, prove it. And when you make your case to prove that you should get more, the courts may not agree with you. Then you have a problem. Okay. Number 3, the court's jurisdiction may be exercised to allow a trustee to be compensated for blank or blank services to the trust. Blank or blank?
Past or future.
Past or future services to the trust. Number 4, a trustee may enter into agreements with beneficiaries who are blank and blank to be remunerated from the trust fund. Blank and blank again?
Where's just
Beneficiaries who are, trustee may enter into agreements with beneficiaries who are of sound mind and age. What do we call that in Latin?
Sui juris.
Absolutely. Sui juris. It's a Latin expression meaning of sound mind and age. And the other blank?
Absolutely entitled.
The entitled.
Yeah. In other words, the beneficiary, if the trustee is going to enter into any agreement with beneficiaries, they must be of sound mind and age and absolutely entitled as a beneficiary. Because some beneficiaries are not absolutely entitled depending on the arrangements with the trust. They may just be residual beneficiaries and only entitled if something else happens, which may never happen. So they have to be absolutely entitled. And sometimes there's a big argument in court and elsewhere as to who's absolutely entitled. All right. Number 5, what is the general principle regarding trust remuneration relating to assets situated abroad? What's the general principle? In the Bahamas and the UK, for example, you just saw it. What's the general rule for remuneration?
If the law where the property is allows remuneration for trustees, they won't be bound to account for it unless they went out of their way to get it.
Indeed, no need to give an account unless. No need to give an account for remuneration unless the trustee has gone out of his way to get it. What is out of its way? It's all relative. There's no defined, perfect expression for out of its way. Out of its way is out of its way as deemed to be out of its way, depending on who brings an out of its way issue. There are no defined steps. That out of its way means A, B, and C. Okay. Number 6, under the rule in Keach versus Sanford, the trustee is not permitted to allow his blank and his blank to conflict. Blank and his blank?
Is that duties and interest?
Yes, absolutely. Duties and interests and duties. They should never be allowed to conflict. Same thing as you guys. If you're working somewhere and you're doing a job that might conflict with something else you're doing outside of work, you need to consider whether that conflict is real enough for you or not. Because you might be doing some outside work and that might be fine as long as it doesn't conflict with the job that you're on in any way. Okay? Same principle for the trustee. They must make sure that their own personal interests as a trustee and even as an individual do not conflict with their duties as a trustee. Notice we didn't say with the powers of the trustee. See, because remember, from Unit 6. Duties and powers are not the same. Make sure you know the difference when testing time comes. That duties and powers are not the same. So if you get a question, describe the duties and powers of the trustee, for example, in any form or fashion, and you put they are synonymous, full stop, and go to the next question, that's a big problem for you. Don't do that, because they're not. They're very different. Number 7, a trustee is also not allowed to take any blank from his position as trustee if not allowed by the instrument, the beneficiaries, or the courts. And that blank is? Not allowed to take any blank from his position. Starts with P, the big P.
Profits then.
Yeah, the almighty profits. Remember, people are always looking to get money, make money, steal money, embezzle money, hide money. Oh, folks are always looking for ways to get money, profits included, unauthorized profits, illegal profits, money laundering profits. This stuff is going on every day. Don't think that everybody that you see with stuff got them working hard like you did. That's not necessarily true. People are doing all kinds of interesting things, and then if they don't get caught, and if they manage to launder it and invest it in stuff that cleans it up, or whatever it is folks do, then they'll come back to some banquet and say they've worked extremely hard over the last decades to acquire the wealth that they have gotten. And they encourage all of the young people present to be diligent in their efforts as well. Okay? All right, profits. Number 8, a blank in the trust instrument will be allowed even if it may enable a trustee to gain from his fiduciary responsibility, and even though it may produce a conflict of duty and interest. A or and blank.
Express charging clause.
Indeed. Does anybody realize what the word express means yet in the context of what you're studying right now? What does express mean? What do you think the word express means?
It's very clear in its
In what
intention.
way? Yeah, very clear. In what way? You're on your way. In what way?
Maybe specifically laying out how much should be charged.
Yes, when you say laying out, what do you mean?
Give me some figures.
Yes, and meaning, I know I'm dragging you through it for a reason. All of the above is correct, meaning that all of this should be what? In?
It has to be in the deed and it has to be agreed on. So it
Yes,
says exactly what's going to who.
yes. In other words, it has to be in writing. That's what expressed means. Okay? When we're talking about this stuff you're studying, and in general, expressed means in writing as opposed to what? What's the opposite of in writing? Verbal.
Verbal.
Do you know that contracts can be made verbally? Did you know that? Probably not, but you can make a contract verbally. You can have agreements that are verbal. The only problem with verbal, what's the problem with a verbal agreement? Anyone?
I guess you could pretend like you didn't hear something if it's not in your interest or mix it up.
Yeah, if with a verbal agreement, you can deny it, break it anytime you want. Even if you have a witness, you say the witness lied. And then it goes to court, and the court will decide whether they believe the witness or not, given the veracity of the case. But verbal contracts are possible, and they can be enforced too, if you can bring enough evidence to prove that it happened. But it's not the ideal way to contract. The ideal way to contract is expressly in writing, with all that stuff she said earlier, put in the relevant information in writing. And sometimes even written contracts are broken. Did you know that? So I'm not adhering to that contract. I'm tired of it. I don't agree with it. It has a flaw. Bring me as the best lawyer you have so we can find a loophole. So we do not have to honor that contract. Is getting married a contractual arrangement? Anyone?
Yes.
Yes, it is. So much so that the cost of breaking that contract is extraordinary, is it not?
Very much.
Very much. But people still do it. But it doesn't change the fact that the cost of doing it is extraordinary. Point I'm making is it's always good to contract in writing. But even in writing, we break contracts or we seek to present it as null and void. So imagine a verbal contract, even more so, and a more frequent, more frequency. Like, did I say that? Like the guy from the sitcom. Did I say that? I don't recall. Prove it. Bastard, I didn't mean it anyway. I was just trying to get out of something. And so on. All right, number 9, a trustee cannot purchase blank for himself.
Trust property.
Trust property. Trust property. Too much conflict of interest there. Besides, the assets were not there for you to purchase as trustee for your personal use and gain. It was there only for the benefit of the beneficiary and nothing more. And if anybody other than beneficiaries are not going to benefit, it shouldn't happen unless, of course, all the beneficiaries agree. See how that works? All. How about that? And sometimes if all agree in the trust and the protector finds out, the protector might say, how the hell did this trustee get to persuade all of them? Did he bribe them? Did he, whatever the reason, say, you know what, I don't agree with that as trustee. I'm going to take it to court and see if I can have it overturned, even though all the trust beneficiaries agree. The point I'm making is these matters are never final until they get to court. If somebody decides to take action. Okay. All right. Speaking of the breaking of contracts, let me get a perspective from you young ladies in the class. Typically when there is a contract broken in terms of a divorce, if a man is rich, his wife tend to benefit if he's rich and she's not. If a man is poorer, who benefits more, him or his wife? Let's say he's a regular working guy. He's not
Probably
rich.
the wife.
Yeah, in most cases, the wives benefit. Does anybody know why that is so?
I don't know if my theory is correct, but I always thought it was two things. Wives usually end up having to take care of children if children are a part of the union, but then also maybe the way the law had been set many years ago when wives were never breadwinners, so they had to depend on.
Correct. I couldn't put it better myself. The original premise was back in the day when husbands went to work. Some wives stayed home to look after the children, keep the home, keep stability in the home. Men went out to war so that our women and didn't have to go out to war. Somebody had to be home with children, whatever the case might be. That whole old school thing, which still has a great deal of veracity today. But of course, we know much more women are in the work field, and in some cases dominate the work field. And so there's an interesting shift going on, which means that since there's a shift going on, I suspect eventually there might be a change in laws, hopefully, where now that women are no longer at home, should she be the beneficiary of the divorce or not? So now it's going to get interesting, like how do we manage that part of the contractual arrangement once it's broken? So you youngsters have a lot of things to think about personally and professionally. I just threw it out because it came up as part of this trust thing. And it is part of the whole trust thing anyway, because after all, when we get married, somehow we end up being in position of trustees anyway. My. It's fascinating. All right, and then number 10, any purchase of trust property by a trustee at the instance of a beneficiary will be, no matter how fair, open, or honest the transaction may have been. Sorry?
Voidable.
Voidable, yes. No beneficiary is allowed to make any deals to purchase trust property, no matter how much in good faith. Because see, some beneficiaries, even if it's one beneficiary, To see if you're more than one, then you need everybody to agree before you can sell trust property. But some trust arrangements have only one beneficiary. And some trustees, they are a little shrewd. Or some beneficiaries, they want to get rid of the asset because they want money now. So whether the trustee is shrewd or whether the beneficiary needs money now, whatever the reason is for the arrangement, if it ends up in court for some reason, it will be declared void. Again, the protector might find out that the trustee found himself making a deal with the beneficiary who has agreed to an arm's length agreement to sell his or her $10 million home to the trustee for some reason. And the beneficiary said, I want the money, I don't want the home. And then the protector says, well, why you did it with the trustee? And the trustee should know better. This is supposed to be keeping this home for the benefit of the beneficiary and all this kind of stuff. Right? And if it eventually gets to court, the court will declare it to be void under those circumstances. Okay? Unless, of course, some other situation, see, number 3, come into play and is presented to the court. All right. Some fantastic questions about the reality of the trustee remuneration and some interesting outside information comes up as a result. And the good thing about that is as a trustee, you'll discover later on as you get more and more into the profession of trusteeship that your job will not always be a straightforward one of administering a trust. Bear in mind, administering the trust is first and foremost for the benefit of beneficiaries. Beneficiaries are not robots, they are human beings with all kinds of idiosyncrasies that you sometimes cannot imagine. And sooner or later, some of those idiosyncrasies will arise outside of the nice, clean trust deed that is supposed to make your life so much more comfortable. Okay? All right. So if there are no other questions about remuneration, I think you have a lot to ponder in terms of the remuneration of the trustees. A very interesting area that trustees are not automatically allowed to be remunerated, that it has to be an instrument, that if they want to make a change, they have to go to the courts. That the courts may or may not agree, that even if they're in breach of trust of getting payment when they shouldn't have been paid, that depending on the work they do and how well they've done it, the court will say it's okay. Just don't breach it anymore going forward. Let's make an arrangement that is reasonable, or what you're charging is not reasonable, Mr. Trustee, or what you're charging is unreasonable, and so on. So all these things come into just the trustees' fees. And we don't hear about this stuff in normal day-to-day stuff because these things go on behind the scene. But rest assured, they go on. I had a client once that I was doing some consulting and blah, blah, blah for a couple of years. And I said to the client after a couple of years, the initial fee that I charge you is an introductory fee so that you can be persuaded to take on my services. But your company has grown, just like the trustee. Sure. Your company has grown, Mr. Client. And so what I charged you back in 1982, or whatever year that was, it no longer applies. Now, some business owners, they look at it and they're reasonable. They say, you know what, that's true. I think it'll be fair for you to increase your remuneration based on what's happening now. And others, they'll look at it and say, really? Man, I don't see any reason why it should be increased. And if you try to increase it, I'll find somebody else. And that's part of what they use to try and force you to keep the old thing. And then you, as the service provider, have to say, okay, sorry, man, I need the 10 cents really bad still, so I'll leave it there, or find somebody else and you'll discover what you'll discover. If you change your mind, my number is still. And so this is a day-to-day example of the kind of thing that will happen when it comes to remuneration at the trustee level, except more and more intense, okay, depending on the situation. All right, Unit 8, this other part of the trustee's job, retirement and removal of trustees. Some trustees retire voluntarily Others have to be removed from the jobs for one reason or another. Okay. Trustees do not always do their jobs according to the requirements, and sometimes they have to be brought into question and removed. Some of them have been dealing with the trusteeship for so long they decided they're retiring. Period, and so therefore they need to have another trustee take over the trusteeship or liquidate the trusteeship and move on. Okay. The problem is it is sometimes easier said than done. So there are some conditions under which a trustee may be removed for one reason or another. What are the conditions with regards to the retirement of trustees? How does that work? And what jurisdiction does the court have with regards to the removal of trustees? And these are some of the questions swirling around retirement and the removal of trustees. So back in Unit 6, we saw the powers and duties, like, this is what I'm here to do. Then we talked about payment, like, okay, I'm doing all this crazy stuff for this trustee. I think I should be paid X. And now we get to the other side, which is, well, what happens when it's time for the trustee to retire? And what happens if it deems that the trustee be removed, and why? And if we remove a trustee, what happens then? Okay. So this is now the other side of the fence a little bit. Kind of like, in a way, the succession side to some extent. And what's going to happen to the trust when retirement and removal issues come up. Okay. That's really the point. All right, so let's look at the retirement of the trustee first. Let's see how that works. All right. I wonder if anybody from Scotiabank is here yet. Melissa, are you here yet with us? Where are the Scotiabankers? Okay, Janice, are you still here?
Yes.
Great. Janice, why don't you kick off the retirement of a trustee? Let's see what happens to the trustee on the retirement issue.
Okay. Retirement of a trustee. A trustee may retire by an express clause in the trust instrument under Section 47(2) of the Trustee Act, by the beneficiaries sui juris, or by the court. A trustee may retire without a replacement if there are at least 2 trustees or a trust corporation. He may also retire where the existing trustees consent to his retirement, or the trustees may execute a deed of retirement. Where the requisite consent cannot be obtained, the court has the inherent power to discharge the trustee without a replacement. A court will discharge a trustee provided there is at least one other trustee who will continue to act as trustee, or a new trustee is capable of being appointed to the trust. This equitable principle is to ensure that the trust continues to operate in the best interests of the beneficiaries, taking into consideration the nature and extent of the trust. A trust instrument may contain an express power which allows a trustee to retire. Additionally, there are provisions in the Trustee Act of 1998, which also permits a trustee to retire. A trustee may retire by obtaining the consent of all beneficiaries who are sui juris, and between them absolutely entitled to the whole beneficial interest in the trust. Another way for the trustee to retire is to obtain the consent of the court. A trustee who seeks to obtain the consent of the court to retire from a trust will be required to pay the cost of the application for such discharge, except in the instance where he has demonstrated to the court that the trust has changed significantly from his initial appointment and or acceptance to act as trustee of the trust. A retiring trustee of a trust normally requests a release from liability in relation to his trusteeship, which he may be granted on termination of the trust. Where a new trustee is appointed upon the retirement of a trustee, the release from liability may not be granted, depending upon the circumstances.
Thank you very much, Janice, on that expose with regards to the retirement of a trustee. I think we gathered from that information that yes, there's no doubt that the trustee can retire, but we do know now that there are some impediments to the retirement. You don't just get up and walk off like, I'm tired of this, see you guys later, or I'm tired, or I'm old, or they might all be reasons, but you don't just get up and do it. There are some requirements if you are a trustee, which is one of the other things that makes this fiduciary responsibilities trustee so serious and so important. Okay? Notice the discussion opens immediately with the fact that a trustee may retire, but by what? An express clause, see, in writing under the act. That's the first condition. Okay. And the trust instrument again, the trust instrument, that's the Bible of trusteeship, the trust instrument. Whenever a trustee has an issue or concern, the first place they should go is to the trust instrument to see what it says. Then, if the trust instrument does not have the requisite information or permissions, then the trustee is required to go to the Trustee Act and its amendments. Next, if the Trustee Act does not provide for what the trustee is seeking, then the trustee may go to the beneficiaries. And then finally, as you now know, to the courts. The point is, there's a process involved. Sometimes it's simple, sometimes it can be a little complicated. Okay. So can a trustee retire? Yes. Without a replacement? Typically, no. That's why we're told in the second paragraph, which Janice is reading, that, yeah, you can retire if there are at least two other trustees or a trust corporation who can pick it up. And notice we say if there are two trustees or a trust corporation, meaning a professional trustee. So let's say you are an individual trustee and you wish to retire from that trust for some reason. You may, under this particular discussion, if there are at least two other individual trustees who are prepared to pick it up, or a corporate trustee who's prepared to pick it up. That's one of the conditions. That is designed so that a trustee doesn't walk off and leave a trust hanging in midair. Because if that should happen, then it puts the beneficiary's position in jeopardy in terms of the management of the assets of the trust. Okay. Notice the second condition, he can retire under, if they're existing trustees, they have to, if they consent and execute a deed of retirement, then he can retire. What do you guys think would happen if the existing trustees don't consent? Like, we don't agree to your retirement, Susan. What happens then? What does Susan do then?
I guess
Oh, so-
follow the chain.
Say it again.
Follow the chain, I guess, and end up in court, maybe go to the
In
court
court,
to apply.
Yeah,
Right.
ultimately, Susan might say, okay, the existing trustees don't agree. Before they go to court, where might she go first?
The beneficiaries.
Absolutely. Presuming that the instrument doesn't give her the right to do it first. If the existing trustees don't do it, she might go to the beneficiaries and say, guys, I want to retire. The trustees don't want to give me the deed of retirement so I can get out of here. And they might say, well, okay, well, we'll all agree to give it to you. That will work. Or the beneficiary might say, we don't want you to leave either, for whatever reason. So now she has no choice but to go to court. Okay. Interesting. So again, the court is the last resort for most conflict issues, not only in trusteeships, in general. Interestingly enough, where the retiring trustee does not get consent for any reason, the court also has the power to discharge the trustee or send them into retirement without a replacement. How about that? Chances are that would be under very rare and guided conditions, and perhaps the trusteeship would then be brought under the trusteeship of the courts until a new trustee can be appointed. Because by the time a retirement issue gets to the court hears all the issues. There might be too much water under the bridge. The court might decide this person wants to retire. They've been fighting to get this retirement. If we send them back and say you cannot retire until, then they might fail to administer the trust as adequately as they should as a result of the fact that they're ready to go. Some people have already pissed them off about leaving and so on. So the courts, and its inherent wisdom and power, may still go ahead and discharge the trustee to retire without a replacement trustee, bringing the trusteeship bringing the trust under the trusteeship of the courts until the matter can be resolved. I've had a case not too long ago where a financial institution had an issue with some of its principals who it thought might be dealing in fraudulent behavior, etc. The problem is these principals were former owners of the financial institution, major shareholders, and so the current management and board of the financial institution was uneasy about some of the investment or the practices of the former owners of this financial institutions who've been giving further instructions to do stuff they were not comfortable with, blah, blah, blah. So they have a dilemma now because now they believe that some of the activities are fraudulent, maybe money laundering directed and so on. And the principals are now giving them instructions to transfer funds elsewhere. They don't want to do it. They want to find out if the person, and it's a whole long, the point I'm making is these things happen. And so the question is from the financial institution is there any way we can even get the courts to delay or freeze these funds until we are satisfied that either these persons are up to no good or they're not? Point I'm making is outside even trusteeships, organizations are often before the courts seeking a redress of some kind or another because the courts are considered the place of last resort. Okay. All right. It's interesting. Notice we are reminded later in the paragraph that if you want to retire, go back to the instrument. We keep saying that. And the reason why we keep saying that is because even professional trustees, they just do stuff sometimes in violation of the instrument, either out of ignorance, unfamiliarity with it, haven't seen it for a long time, or they know and still do it. Okay. It's like you go into certain societies, for example, maybe in the Eastern world, where they say, if you steal, they cut off your arm. You would think that you would only see maybe one or two persons with their arms off, but if you move around enough, you'll see a lot of people with their arms off. What's the moral of that story, students? In real life, in those countries. What's the moral of that story? You'll cut off your arm. You think you'd only see one or two arms off, but yet you see many arms off. What is the moral of that story?
They can't be trusted.
Indeed. And even though people run the risk of losing an arm, many people will still what? Break the law and try and get away with it. See? Imagine that. Okay? So it's the same principle. And so again, we have to have a place of last resort because no matter what, folks still seek to violate one rule, one law, one circumstance, or the other. Okay. All right. So the trustee needs to go to the instrument, find out if it says it's okay and what are the conditions of my retirement. If there's nothing in the instrument, you go to the act. The act will say you can retire if you do this, this, and this. If the trustee cannot find satisfaction there, goes to the beneficiaries. The guys, I've had it. I've been here with you guys for 20 years. I need to go. I've been here for 3 years. I can't take it anymore. Whatever the case might be, I need your consent. The beneficiaries say no, we're not going to give our consent. Or some of them say yes, others say no. So now you have to go to the courts. Okay? And that is the key. So leaving a trusteeship can be as simple as 1, 2, 3, or as complicated as do, re, mi, right? In the real world. Okay? When you retire as a trustee, does that release you from liability? Not necessarily. Because some trustees try to retire in order to get away from liability that they know is in the trust or they know are coming. That suits are coming because of their behavior. So they try to retire before the stuff hits the fan. And therefore, when a trustee says they want to retire, especially a professional trustee, courts, for example, are always interested in why the trustee wants to retire. And they're not quick to want to give them a release from liability in case some lawsuit or some existing situation comes up to the forefront, that the courts and others can still go after the retired trustee for their role in whatever the mess might be. Okay? So yeah, you can retire. However, we are not releasing you from liability necessarily. Because if something comes up and you're a part of it, we need you to be responsible for your part, Mr. Trustee, who's retiring in it. Right? So again, some retirements are genuine, some retirements are legitimate, and some retirements are orchestrated because of what the trustee might know to be coming, and therefore they jump ship, quote unquote. Okay? Notice some of these common law cases that you've been saying go way back to the 1800s. Some even go further back. And then some are very modern and 19 something. Have you guys seen any cases in 2021 so far? Common law cases? 2021, dated 2021, like this one says 1844. Anything for 2021? No? Okay. All right, so then now that we see how the trustee tries to manage his retirement, we now come to that other part, which some people feel to be the opposite of retirement, which is removal. And what are the terms and conditions for removal? Okay. Ms. Francis, are you still there?
Yes, sir.
Great. Would you believe we're back to you already?
Mm-hmm.
She said, oh, that is me again. And the reason for that is we have two colleagues from Bank of Nova Scotia who are not with the group today, who would have been involved to give others a break. So welcome to the real world. It's like when somebody doesn't come to work. You know all about that, right?
Yes, sir.
When somebody doesn't come to work, they said, Ms. Francis, Suzette didn't come in again today. We're afraid you're gonna have to pick up. Doggone it, Suzette. Because every time she doesn't come to work, or he, and yeah, somebody has to pick it up. All right. Yeah, and folks have to remember also, when you don't show up, it's not just that you don't show up. What you do is you put a burden on
Somebody else.
yeah, somebody else.
Mhm.
Some of us really don't care, like the hell with it. Right? So what to be a burden? I'm out of here today again. All right. Okay, for the removal of the trustee. Let's see if that's similar to retirement or if this is a different ball game for the trustee altogether. Okay, the court may.
Okay. Removal. The court may also remove a trustee where he is unfit to act, refuses to act, incapable of acting. The court can remove a trustee without replacing the trustee. See Letterstead versus Brose, 1844, 9 Appellate Case 371. The removal of a trustee by a court is normally based upon the actions of the trustee, which may be due some dishonesty for which he may have been formally convicted, or some financial irresponsibility with regard to property under his trust, or by him becoming a bankrupt. A court may also remove a trustee from a trust where there is found to be continuing friction between the trustees and the beneficiaries. Example, for substantial overcharging by the trustees, and the fact that the trustees would have a difficult task of administrating the trust in the best interest of the beneficiaries if left to continue to act as trustees. Letterstead versus Rose, 1884. In the case of Vaso versus Chase Manhattan Corporation Limited, 1994 Supreme Court, the Bahamas, number 1261 of 1992, unreported. The court suggested that to remove a trustee, there should be proof shown of some misconduct or mismanagement of the trustee assets, and not merely that the beneficiaries are unhappy. In this case, 4 of the beneficiaries sought the removal of the corporate trustee, as the company did not sell the 49% in the partnership as directed by the settler, who was given power so to direct in the trust instrument. The discussion centered on the trustee's standard of care, Spite versus Gunn, in which the judge stated that it is not indeed every mistake or neglective duty or inaccuracy of conduct of trustees which will induce the courts of equity to adopt such a curse. The acts
Yeah.
on
I know it's a strange word, but that's how judges are. It's kind of a dark euphemism for some not so acceptable behavior. Such a curse. Yes.
Okay. The acts or omissions must be such as to endanger the trust property, or to show a want of honesty or want of proper capacity to execute the duties, or want of reasonable fidelity. The court held that it was in the best interest of the court to remove the trustee, as the trust had 6 years before it came to an end, that the asset had been liquidated and dispersed to the beneficiaries. Additionally, the decision in McPhail versus Dalton reiterated the principle that if trustees are unable to administer a discretionary trust, the court could appoint new trustees to do so. A trustee may also be removed under a power within the trust instrument or by statute. The circumstances surrounding the removal of a trustee under a power within the trust instrument must be clearly related to the power of removal, since the power will often be strictly construed, and the removal of a trustee may impact negatively on the trustee from a moral standpoint.
Indeed, indeed. Thank you very much, Ms. Francis. So
You're
now
welcome.
we see that the retirement and removal of the trustee are 2 different environments, pretty much all together. Okay, the retirement has other implications, but the removal starts out with the fact that the court, saying right off the top, the reasons why a court may remove a trustee: because the trustee is unfit, the trustee refuses to act as trustee for some reason, God forbid, or the trustee is incapable of acting for some reason, personal, professional, or otherwise. Okay, and under these conditions, the courts may remove a trustee without replacing that trustee. Will it replace the trustee eventually? Maybe, maybe not. It might put it again under the trusteeship of the courts, or it might designate a temporary trustee who will manage the assets of a trust until a formal trustee is appointed for that particular trust. Right? The company that I mentioned to you, financial institution, has issue with its former owners and current clients, etc. The trusteeship of the assets of the firm has been placed temporarily in the hands of an audit firm who is acting as trustee until such time as a decision is taken as to what will happen next to those assets. Similar kind of situation. Who made that decision? Obviously the courts. made the decision to place it in the hands of an independent party. Okay. All right. So those are some of the main reasons why a trustee may be removed. Okay. Something really heavy has to be going on when we get to discussions about the removal of a trustee. And so therefore these matters are always contentious, because oftentimes trustees are dishonest and unfit and doing illegal and immoral things, believe it or not, even though they are the trustees of the trust. Some trustees, because of their illegal behavior, white collar crime, etc., money laundering, fraud, tax evasion, whatever they're doing, they end up being convicted, going to prison. They have to be removed. They cannot be in prison as a trustee. Okay, so to speak. Financial irresponsibility and bankruptcy. The key there is, if the trustee is financially irresponsible and a bankrupt, should they be managing the trust on behalf of the beneficiaries? And the answer is resounding no. Unless, of course, there's some extremely unusual reason why that happened in an isolated case. But generally, no. We don't want such a person or institution to be administering a trust on behalf of beneficiaries. You have to be reputable and capable. That's the point. Otherwise, you'll be deemed to be an unfit trustee. And that makes sense. Okay. I don't think anybody in this room would turn over trusteeship to a known ex-con, unless, of course, the person was innocent and ended up in prison incorrectly, and you can prove it. But typically, you think twice. Does that mean that somebody's gone to prison cannot be reformed? No, it doesn't mean that. It just means that typically, all too often, they're not reformed sufficiently. We have exceptions to every rule. And even if it is so, the perception is, okay, and so on. Right? That will still lead to the removal. In other words, if you're a trustee, you have to keep your nose clean. If you're a pastor of a church or bishop, you have to keep your nose clean. If you're head of an organization or a board, you have to keep your nose clean. If you're responsible for supervising people, you have to keep your nose, see, like that. It's all trusteeship, either directly or otherwise. Wow. So, also bear in mind that a trustee cannot be removed just because beneficiaries do not like the trustee. Some beneficiaries and trustees do not get along because of differing personalities, because of perceptions, and because of other things that come to the forefront. See that number 3 again, other relevant matters. And so sometimes the beneficiary doesn't like the trustee. Sometimes the beneficiary doesn't like the trustee just because the trustee wouldn't do what they say. Remember also, sometimes settlers are beneficiaries. And if a settler is a beneficiary and the settler tells the trustee to do something, they don't do it, then the settler is going to get mad with the trustee and make their lives miserable and seek to have them removed, get another trustee, which is one of the problems of having a settler as a beneficiary as well. Okay? And so again, the courts are not just going to change or remove a trustee just because you say so. Beneficiaries and others will have to give a good, sound reason for doing so. In the Bahamas case, well, they get upset with the trustee because the trustee wouldn't follow the instruction. In this case, the settler was a beneficiary, so that didn't help. Okay. But we are told that what? The court still ruled because there were other extenuating circumstances. The whole thing is going to be finished very shortly anyway. The assets have already been sold, etc., etc. So that's an extenuating circumstances. Had this just been a normal trust without extenuating circumstances, the courts probably would not have ruled for removal because there's no sound basis for doing so. Okay, for sure. This case, this Bahamas case, because it's a Bahamas case, you guys may want to have a look at that just for the hell of it. Say, hey, Bahamas case. And see, because if something happened in the UK or some other place, oh, God, that's the Queen of England or somebody. But this is a Bahamas case. You may want to take a moment to 10 minutes, look at the opening salvo, like what are the tenets of the case, and what was the final decision.
I have a question.
Yes.
With regards to that particular case where they said that the asset had been liquidated,
Right.
if there are no asset is there really still a trust?
It could be technically, depending on where the liquidation process is. You follow? That's a hell of a
So
good
it could be
question.
in the process of liquidating, then not fully liquidated.
That could be one reason. It could be that the assets have been liquidated, but the cash not yet distributed.
Okay, okay, all right.
See? So again, it all depends on where the matter is. You see, because sometimes liquidations occur because of business decisions, and sometimes liquidations might occur for the direct benefit of certain people, which oftentimes may not be legal or even moral to do. So sometimes folks are running all kinds of little subtle programs that people are not aware of. But on the surface, yeah, you could liquidate and still have issues pending before the whole matter is closed, and therefore the trustee should still stay on. Or if the courts deem that, okay, fine, liquidation is done, the money's in the bank, the courts can take it from here, then they'll say, fine. The trustee can be removed because there's nothing substantial left for the trustee to do. If there's something substantial left for the trustee to do even after liquidation, then the courts may rule against removal until that's done. You see how that works?
Yes,
Okay.
okay.
All right. And so what does the judge say in Gaunt? Like, hey, we're not going to just remove a trustee for every mistake and neglect of duty and accuracy that they make. You will not induce or persuade the court of equity to adopt such a curse to remove such a trustee because they made a mistake or they had an isolated neglected duty or something. The courts are not into that. We're a court of equity. So we try to do what is fair. That's really what the judge in Gaunt is saying. Okay. Only if the acts or omissions by the trustee are such to endanger the trust property or to show a lack of honesty or proper capacity by the trustee to execute the duties, or a want of reasonable fidelity, meaning the trustee is an infidel, not being faithful in his duties, then this bloody court of equity will execute such a curse. But until then, please proceed and not waste the time on the court, so to speak. But doesn't keep people from bringing action anyway. Okay? Who are the beneficiaries? Mostly those situations, lawyers, who we hope are charging reasonable fees. Reasonable is always in inverted commas. So what is reasonable? Okay? But you guys will figure that out in your own time and circumstance. All right. So sometimes the court may find it of the best interest to remove the trustee, depending on the situation. Okay? In this case, we saw the trusteeship is coming to an end, the assets have been liquidated, the courts decided that there's no substantive reason. In this case, to go further with that question that was asked earlier, notice there's a third thing to this particular set of assets. Not only had it been liquidated, but what else happened? Anybody sees it? What else substantive happened to those liquidated assets? Anyone? In this case, the Gaunt case.
It was distributed, eh?
They were disbursed, yes,
Yeah.
to the beneficiaries already, not pending. And therefore, substantively, there's nothing else and no reason to keep a trustee on. Had they not been disbursed, there might have been a substantive reason to keep a trustee on because the trustee has the details of the details. But in this case, they've been dispersed, the beneficiaries have it, and the matter is closed. Okay. So these are some very not surprising, but very interesting conditions under which a trustee can be removed. And typically, these are some of the things under any conditions under which any trustee. Remember, we're talking about a professional trustee, but a lot of us have constructed trustee responsibilities in our job as financial institutions, persons who work in financial institutions, who manage people's monies, manage people's informations, doctors, lawyers, accountants, all these other people bankers and so on, pastors, counselors, all these people who hear people's private stuff. People go in the hospital for different problems. We have a trustee responsibility, not like when we leave work, call somebody and say, you know what? Do you know that Janice only have 8 toes, Felicia? And she's like, really? What the sick? I didn't know that. We cannot do that in any capacity as trustees, whether it's formal or otherwise. All right. So I think we've made it clear today, I hope, about the differences between the retirement and the removal of trustees, that they are not synonymous. Okay? They are antithetical to each other. They are not the same. One is east and one is west. And the conditions governing both have very different conditions. Okay? All right. So I think you guys have been amazing again to get out of your nice warm beds to mess with this crazy trust stuff. And hopefully I've left a few tidbits with you again to think about as we get ready for our last and final session next week. So for next week, please, if you haven't done the self-assessment for Unit 8, go ahead and do that. Take a look at Unit 9 and do the self-assessment for Unit 9. And when we come next Saturday, we'll do all of that stuff along with any other interesting, exciting questions that you have, because you've certainly raised some very good ones, some very pertinent ones in the last 2 sessions, and that is always a good thing. I'm sure everybody benefited from those questions. Any other questions before we break for today? All right, fantastic. You guys be safe, and I'll see you again next Saturday, same time. Okay?
Thank you. Bye, everyone.
Okay, thank you. Bye-bye.
Bye-bye.
Thank you.